All right, we are at interpreting and applying the First Amendment with respect to freedom of speech. Now, a lot of times people will speak of freedom of expression, and that's not what the First Amendment protects. The First Amendment protects freedom of speech and the press. However, oftentimes the Supreme Court has interpreted it as if it said freedom of expression. What they're trying to do is they're trying to create a buffer zone because they think this concept, this idea of freedom of expression is so fundamental to a free society, a free government, that they just need to put a hedge about it. So the traditional view was articulated by William Blackstone, an English jurist. He said, a free press is essential to a free state. This is the idea I just articulated with respect to the Founding Fathers. But then he added, but the freedom the press should enjoy is freedom from prior restraint. What he meant by that was that there should be no censorship in advance, that a person, a paper, a broadcaster today could publish or speak whatever they want. But for Blackstone, once the publication of speech was made, the author or the broadcaster had to take the responsibility for the consequence if what was said proved to be improper, mischievous, or illegal. That's what had to happen. So this freedom of speech in Blackstone's day was different from the freedom of speech in our day. So in other words, if you said something and if it had one of these characteristics, improper, mischievous, or illegal, then you better not say it because you would be held accountable for what you actually said, even if it was true. Now, the first time Congress passed legislation respecting speech was with the Sedition Act of 1798. It followed Blackstone's view, but with some improvements. It jettisoned the bad tendency test. So what do I mean by the bad tendency test? This is the bad tendency test. That if something that was said proved to be improper, mischievous, or illegal, it had a bad tendency. And if it had that bad tendency, whatever you said, you could be held liable for it. So when Congress passed the Sedition Act of 1798, they got rid of that. They threw it overboard. There was no more bad tendency test. You could say whatever you want, so long as the statement was true, which was really part 3. 1 and 3 were in essence saying the same thing. In addition to that, it made a serious improvement over the Blackstone view by putting determination of guilt in the hands of a jury as opposed to the hands of a judge. Judge is one individual employed by the government and seemingly would take the government's view, but by putting determination of guilt in the hands of the jury, there's your peers, your fellow citizens, stand as a check between you and the law and larger society. So these were some significant improvements that Congress made in the Sedition Act of 1798 versus the previous Anglo-Saxon view of free speech. Now, nothing really happened with Sedition Act of 1798. If you'll recall, this was when John Adams was elected president and Thomas Jefferson was almost elected president instead of Adams. This was an attempt by the Federalists to control the Jeffersonian Republicans and stave off the tide of Jeffersonian Republicans that were seemingly sweeping the country. And so when Jefferson got elected 4 years later, anybody that was arrested under the Sedition Act of 1798, he just let out of jail. So there was no case that came before the court for them to rule on this on the Sedition Act of 1798 relative to freedom of speech. The next time the United States Congress would pass a law that would touch speech was 100 years later, and that was during the Espionage Act of 1917. As a reaction to World War I. This was Mitchell Palmer. We talked about policy entrepreneurs at the beginning of this series of lectures. And everybody believed that was part of Congress, that the Sedition Act of 1798 swept too broadly. And so they tried to bring it back down a notch. And so what they what they criminalized in the Espionage Act of 1971 was the advocating of treason, insurrection, and forcible resistance to federal laws or attempt to foment disloyalty or mutiny in the armed services. That was illegal. Now, if you can see this is clearly speech. So the question becomes, can Congress pass a law that touches speech? Fascinating question. It seems to be clearly directed at speech, and the First Amendment clearly says you can't do that. So here comes our case. Charles T Shank. He was convicted at the district level, that is the lowest federal level, of violating the Espionage Act by mailing circulars, pamphlets, to men eligible for the draft and urging them to resist. This seems to be the very essence that the First Amendment was designed to protect. This kind of speech. So this is what he's doing. He's just stating his political beliefs, and he's telling men they ought to resist. He's telling men they ought to resist. That's what he's doing. He's just talking. Now, what's another way to look at this thing? Has he advocated treason? I don't know. Is it treason to resist? Insurrection? Forcible resistance to federal law? Foment disloyalty or mutiny in the armed services? Would that do that? And even if it would do that, does that suggest then this is a violation of freedom of speech? And so he is convicted, though. He's convicted. So what was the Supreme Court thinking? There were two views with respecting the First Amendment and the Shank case. The first view, the First Amendment said Congress would make no law respecting speech, and therefore, end of story, Shank should be not guilty. The other view was Congress could punish dangerous speech. Dangerous speech. Congress shall make no law abridging the freedom of speech or of the press or the right of the people peacefully to assemble and to petition their government for redress of grievances. Dangerous speech. Peaceably to assemble seems to suggest some limits on this. So what should it be? What should it be? This is what the court ruling was. They said, and this became known as the clear and present danger doctrine. The question in every case is whether the word or words used in such a circumstance, and are of such a nature as to create a clear and present danger that will bring about substantive evils that Congress has a right to prevent. And then they argued that the leaflets presented that kind of danger. That still may not make a lot of sense to you. This third bullet here on this screen may. The reasoning really was this, and they said this later on earlier in the opinion. They said, not even the Constitution protects someone from falsely shouting fire in a theater and causing a panic. So just because you have freedom of speech does not mean you can create a situation. Everybody's enclosed in some theater, and you decided to be fun to see a stampede. So you let off a smoke bomb and start yelling fire, 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 and 5 people get trampled to death. Can you plead First Amendment right of freedom of speech to not go to jail for murder? And the answer clearly here is no. Yes, you've got freedom of speech. That does not mean you can say whatever you want. There are other obligations. There are other rights in conflict. In this case, the right of safety. That's really what's going on. Freedom of speech versus safety and order. And that's what was going on in the Shank case. And Congress, therefore, the courts limited your right to free speech based on this safety issue. Now, the court ebbs and flows on this. So sometimes, like with the Pentagon Papers case, they allowed that. So this ebbs and flows based on what's going on in society and any crisis we may or may not be in. All right, another case, Benjamin Gitlow. This is 1925. He passed out leaflets urging resistance to the draft. So how would you rule? Well, based on the Shank case, you'd have to say, sorry, no right to do that, right? Well, this is a court case that changed constitutional history forever. Now, the Supreme Court upheld his conviction of Benjamin Gitlow. But the difference in this case and the Shank case was this was a violation on a state law. Now you recall, we've said this many times, originally the Bill of Rights only applied to the national government. And so when Gitlow here, he's being arrested under a state law. And the court changed constitutional interpretation and constitutional history forever by saying this to Gitlow. Sorry, Gitlow, you're going to jail. But states, we're putting you on notice that now certain provisions of the Bill of Rights deal to you, that you are obligated to follow them. Well, how is that so? If the Bill of Rights never was intended to apply to the states, what changed? And what changed was the 14th Amendment. This is what the 14th Amendment says. No state shall make or enforce any law which shall abridge citizens of the United States or deprive any person of life, liberty, or property without the due process of law. And that due process of law, the court decided, meant that you had a right against your state government to those guarantees that were found in the Bill of Rights. And so the court, with the Gitlow case, put the states on notice that now they were obliged to follow those guarantees found in the Bill of Rights and give them to their citizens. The test as whether or not, now this wasn't just a blanket, all of the rights guaranteed on the Bill of Rights applied to the states. But some of them would, and here was the test to apply the Bill of Rights to the states. If the right was fundamental to the American scheme of justice, such as trial by jury, then states had to give their citizens that right. Now today, where do we stand on this? We stand here. Every single right found in the Bill of Rights, but about two, are now guaranteed. You have those guarantees against your state government. The only two that aren't is you're not entitled to a grand jury to decide whether or not you should stand trial, and you're not entitled to a jury in cases involving $20 or more. Those are the only two. Everything else applies to you. All right. So in our next video, we'll take a look at this issue. What speech is not protected? What speech is not protected? That will be our next video.